This is continuing courtroom coverage in the trial of James Crumbley from the Hidden Killers podcast from True Crime Today. Now, back to the courtroom.
He shared with you the defendant's communications on November 30th of 2021. And important to note, he was able to show you exactly the path that he took. Because of the cell phone data, some of you were probably surprised and a little concerned about how much somebody can actually know what you're doing. But it's a lot. And we know exactly where he was, what he did, who he talked to, and so we could trace his steps, which turns out to be some of the most critical evidence in this trial. He showed you through the DoorDash search warrant returns the locations of what James Crumbley was doing from the moment he left the school that morning until the moment he called 911. And only after he learned that there was an active shooter at the school did James Crumbley go home and look for the gun. Even though from 11 o'clock to 1 o'clock he had 4 DoorDash pickups and passed his house many times. He was within minutes, many times. And you heard the 911 call by James Crumbley about 14 minutes after he arrived home and discovered that the gun was missing. Bob could tell us, he testified, and we showed you images of the hallway in that school when he processed the scene. And you saw pictures of that. And he told you that a total of 50 fired and unfired cartridges were recovered, and that the shooter fired 32 rounds and 18 were unfired. And we know where he got those 50. You saw that. It's when he pointed them out across the counter when he's with his mom standing a little bit behind her and said, 2. And you also know that James Crumbley knew that, because when he was at the substation and they asked about where this gun was, who owns the gun, where's the ammo, he described it as he bought 2 boxes, referring to his son. Bob Catellis told you that those are rods placed in where bullet holes have penetrated that glass. And as you can see, and you saw other images, this was somebody who knew how to use a firearm. And Special Agent Brandon told you that's immediately what he observed. Those are shots, if landing on a human being, would kill them. Cami Batt explained in detail what her requirement is and what she did that day, and that she knew James Crumbley because in June he came in and he bought 2 more guns, one for himself, which the evidence showed, because he told Jennifer how much did your gun cost? It was $300. And then there was another gun, which was his son's, a Derringer, and you saw the Derringer. She told you that she also sold him the 9mm on the 26th, that his son was present with him. He stated he's had his eye on that gun. She told you that they sell a locking mechanism with each gun they sell, that he was provided the trigger lock statement, and that there was a cable lock with the Sig Sauer when he bought it, and it was provided to him, and the ATF pamphlet solely in existence to just warn people, once again, the dangers of firearms with minors. And she told you that regardless of what kind of mechanism they provide, they always try to provide a tool with anyone who purchases a firearm to make it safe. Sergeant Joe Bryan testified and introduced the video, the recorded statements of James in the substation. James' statements indicate he knew that his son had only one friend and that he left abruptly. He referred to the math worksheet that morning as some doodling on a paper. But that was after the shooting. Before the shooting, we know that he texted Jennifer Crumbley WTF when he saw it. Now he's downplaying it. It's just doodling. When asked how many rounds, he corrected Jennifer and indicated there were a box of 50 rounds that he bought his son. When asked where the gun was, James responded, it was hidden in an armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. We're going to get to that. What James didn't say that day, no mention of any lock. No mention that the school wanted them to get their son help that day, and then when they couldn't, within 48 hours. And here's something you never hear him say. You hear him say the gun was hidden. You hear him say that there was some doodling on a paper, that he was a perfect kid. But here's what he never says. He never says, I don't know how he got it. Never said that. He never says, it was hidden. I have no idea. I can't imagine how he got a hold of this gun. Never mentions that. 4 kids just died. Your son's in custody because he committed a school shooting, and not once do you say, how did he get the gun? And you know why he didn't say it? He didn't say it because he already knew. He knew his son had access to the gun. Christy Gibson Marshall, as we just talked about, heard gunshots, saw kids running in a way that wasn't normal, went towards the shooting, identified and spoke to James Crumbley's son, and you saw that video, how she just stood there. Sean Hopkins. Sean Hopkins was a counselor. He testified that the shooter was looking up bullets the day before. He was aware of that. That morning he was told he was watching violent videos. And he told you that even in a 20-minute period of time, he was concerned enough to call parents and ask them to come to school right then. He told you that he said he needed help right away. He wanted them to get him some help right away. He told you that he was very concerned about the images, but his main concern was for the safety of the shooter. He told you he didn't want him to be left alone. And he said in that meeting, he never received relevant information from mom and dad. It was short. It was a very, very small period of time for a meeting that takes place when you have to come from your work. James was at the barn at the time. Go to your son's school. They were in and out of there in a very short period of time. He testified, they said that just couldn't happen today. They had to work. Now, you've heard the testimony. You know what James Crumbley was doing as employment during that time. And defense counsel and I agree. That is a worthy endeavor, being employed regardless of how you choose to do it. But what's important to note is that DoorDash is not something that you can create your own hours. You can work when you want. It's not compulsory. You can work on the weekends. You can work anytime. Nick Ejak, as the Dean of Students, testified that he was also at the meeting and that James Crumbley seemed irritated. And that at the time they knew only a fraction of what was going on. No one told anybody at the school. They just purchased him a gun. Neither one of them. James Crumbley didn't say, you know what, we had this fight before. They mentioned about the fight the night before about grades, but didn't really discuss it as a big deal. Didn't really discuss the gravity of what it was like for his son, who had one social connection to the outside world, and that person abruptly left with, and that his son found out because he just stopped texting him back. And that he was obviously so concerned and upset that he communicated that to his father because his father reached out to the friend's father. He didn't say that. He didn't say that the weapon wasn't secure. He didn't say that there had been signs that something wasn't right. Now, you may not like what the two people who were employed by the school and had contact with the Crumbleys that day did. You may not like it. I don't like all of it either. But my job isn't to present to you the evidence that just looks good for my case. My job is to present evidence to you, all of it, because this is about the truth. But he doesn't get a pass because you don't think the teachers did enough. He doesn't get a pass for that. And the blame shifting is only meant to send a message, I'm not accountable here at all. Even though I bought the weapon. Even though I didn't secure it. Even though I never got help from my son. Even though I could have taken him that day. Special Agent Brandon testified where he was when he heard about the shooting, what he did when he got to the school, how he traced the gun, how he found out who owned it. He watched the surveillance. He noticed a couple things that were really concerning to him. One, it was somebody that was proficient with a firearm. He did what's called a combat load, which is unusual. The way his stance was, the shot he took that killed Tate. This wasn't somebody that wasn't experienced with a firearm. And logically, he wanted to know where this person was taught how to handle that weapon, where that minor was taught, that 15-year-old. And he discovered that. He testified that the cable lock that was seen in pictures was sold with the SIG, and it was the cable lock that was seen in the photos. And then he testified that they found that cable lock shoved in another gun box in the kitchen in a cabinet behind a door. You also heard him tell you that the minute he looked at that drawing, he instantly noticed the gun. It wasn't just any old gun. It wasn't. And maybe you wouldn't have picked that up. But Special Agent Brandon did. And you know who else would have known? The person that purchased the gun, James Crumbley. Detective Stoyak talked to you about the search. You saw pictures of the search and the house. You saw where the gun box and the ammo box were when they searched the house. It was on their bed. You also saw a map and learned a pretty small house. Pretty small. You learned he had 2 bedrooms. And you learned that in that master bedroom, which was small, there was the bed, some nightstands, and 2 other pieces of furniture. The TV stand, where he found the 2 other weapons that were in a gun safe, a locking mechanism, with the code set to 000, which is the default. Detective Stoyak and told you what others did. He never, ever, ever said that SIG was locked. He said it was hidden. David Hendrick is in charge of the fugitive apprehension team. You learned what that is from 2 law enforcement officials. You learned that on the day the defendants were charged, they left a hotel in Auburn Hills, local, and drove all the way to Detroit in a building that is meant for businesses, not retail. People don't sleep there. And you heard what it was like when he arrived on the scene, when they were searching for James Crumbley and his wife. You heard through the body cam of the Detroit officer, and you heard from Officer Hendrick, and you heard from Luke Kirtley that it was extremely loud. There were dozens and dozens and dozens of law enforcement, and most of them SWAT. Luke Kirtley told you about how James Crumbley was discovered that night. And the only reason he knew it is because it was all over social media with the description, the license plate, and picture of James Crumbley and Jennifer Crumbley. Why? Because they were charged. And even before they were charged, there was a lot of speculation about them being charged. Luke told you about what that building looks like, what it's for, who's normally there at night, not many people, that he shares a wall with that studio that they were found in, that mattress they pulled in was out in the hallway. He again told you how loud, and that it would have been impossible if he was in his unit not to hear that. Officer David Metzke told you that there were tons of officers, multiple agencies, and that they took a 35-pound steel ram to bypass multiple doors, and they used it, and it was loud. I think he testified we have the bigger guys do that. We saw through his body-worn camera the arrest of James Crumbley, who was laying on the mattress and seemed to be wanting to create the impression that he was sleeping. There's a big problem with that. One, we know that shortly after Luke Kirtley went out to see the license plate, that he followed him shortly after, and he was awake. And shortly after that, dozens and dozens and dozens of law enforcement show up on the scene. It's a first floor unit. The windows face that parking lot. Lights and sirens, media were there, yet he's lying on a bed as if he's sleeping. William Creer told you what they discovered. They had bought and purchased, they had purchased items with them, socks, new socks. They had clothing, they had food. There was a whiskey bottle in the trash can. There was ice. But here's the thing that was the most compelling about his testimony. The bag with the 4 phones that were turned off and $6,000 of cash was stored on the other side of the room from the backpack in a lid in a plastic bin with a lid on it. That is strong circumstantial evidence, which is used in this country every day to convict people, that was placed there in hopes that no one was going to find it. $6,000 cash, 4 cell phones turned off, which is odd if you're really trying to get up in the morning and go somewhere, and the alarm was set on one of those phones, but they were off. But what did Ed Wogrowski tell you? He told you that you can't track a phone if it's off. You can't track it. We all learned, if you've learned nothing else, turn your phone off if you don't want to be tracked, because there's all sorts of ways. Lieutenant Willis testified. He showed you the bank records showing what they did when they found out that their son was charged and when there was talk of them being charged. He talked to you about the scene at Oxford High School. And it was a really detailed description of what it was like in that school that day. Because hundreds and hundreds of law enforcement officials went to that school, some miles away. No one asked them to. They just drove there from all different parts. And so it was Tim Willis's job to take all of those people who wanted to help and give them something to do and get the scene processed and start building a case. And answering questions, which is really what an investigation is about, way before you get to a prosecutor. Because sometimes you never get to the prosecutor. Your job is to Go where the evidence leads you. And there were things about this case from the very beginning that just seemed like questions that needed to be answered. And one of them was, that gun was purchased 4 days earlier by James Crumbley, who was the same person who was at the school that day. This is information they're learning immediately. They do a search warrant for the house and for phones, and they find out a lot of information. You saw the video of the shooting. There's a reason we tell the media they have to turn their cameras off. We don't want those images out there. We don't want them to be on the internet. We don't want to encourage another school shooter. And we don't take any pleasure in showing it to you. But it's our job to know the truth and look at it and not look away. He told you how each of those kids died. Hana was hit immediately after he left the bathroom. You saw the image and it was described to you. Madisyn Baldwin didn't run. She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in the head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Shilling was shot in the bathroom after several minutes of being in there. It wasn't immediately. Shooter went into the bathroom, stayed there. Justin knew the shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbley's son shot Justin Shilling, execution style. Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. You heard during jury selection, and you heard during opening, and if my prediction is you're going to hear it again, that this could be you. This could be any of us. This is what this is their defense. That this could be you if you let your kid drive a car or leave with a sharp object. This couldn't be everybody. This couldn't be the person that takes their kid hunting. This couldn't be the person that buys a gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car. Beware of the claim that this could be you. Beware. It is not the case that finding James Crumbley guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself in a courtroom being charged with involuntary manslaughter. It is just not the case, and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbley. We know that Caltech was left out, unsecured, with ammo. Why do we know that? You saw that picture and video and the one he sent to his friend, and you saw the text that accompanied. But before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat. Dexter. That is the shooter's cat. That magazine is loaded, and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber, and the safety is off because red means dead, and Special Agent Brandon told you that. Even if James Crumbley was standing next to his son, that would still be an extremely dangerous way to handle a firearm. But we do know what happened, because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else. All I need is my 9mm pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun. It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I have access to the gun and the ammo. Then we have defendant's own statements. James Crumbley said it's a substation. James responded when asked where the gun was. It was hidden in our armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked, never says it was inaccessible to his son, and again, never says or expresses any surprise on how his son got a hold of it. We know he took him to the range. We showed you videos and images of that. In fact, 8 times we know that happened. We know that throughout June, July, August, September, October, by November, when he begged his dad for the 9mm, and he actually did buy it for him, now he's at the point where he can instruct other people. It's James Crumbley's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbley taught him. He didn't take himself to the range with his dad. This is the shooter 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see? The cable lock. It's not even in a case anymore. And there it is. That's the cable lock that was provided that day, with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found, in that bedroom, in defendant's bedroom, in a safe, in the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the other important thing is, you're hearing a claim that James Crumbley didn't think that he had to lock his weapon up. Okay. It's not about whether you locked the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other 2. Special Agent Brandon read to you the lines, if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32 shots fired that day by James Crumbley's son. How do we know this was foreseeable? The shooter says in his journal, "I have zero help for my mental problems, and it's causing me to shoot up the fucking school." You heard a lot during jury selection and opening about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. "I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal because he was exaggerating or lying." We have the text between James Crumbley's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. "I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up." Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and sad and wanting help. "I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911 so I could go to the hospital." This was in April. "But then my parents would be really pissed. I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And then on April 5th, like I am mentally and physically dying." What did James Crumbley know? He knew the family dog had died. A grandmother had just died. His son's only friend, the one person he had any social contact with, abruptly leaving, can't even text him. Knew his son was completely isolated. Knew he had looked up bullets the day before. Knew he was upset the night before. Knew he had been watching videos that morning, violent videos. And then he sees that drawing. He sees that drawing that morning when he goes to the school, and what does it say? It says, "Help me." How many times does this kid have to say it? He says it in his journal, he says it to his friend, and what is he saying? "I asked my parents, I asked my dad." And then if that isn't enough, he writes the words, "Help me," on a piece of paper. And his parents, James Crumbley, is called to the school to see it. And what does he say? He says, "We gotta go to work." He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier he purchased that weapon for him. This is James Crumbley's son on the morning of the shooting, November 30th, being dropped off, like every day, by James Crumbley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life is useless. The world is dead. This is the worksheet James Crumbley looked at when it was texted to him. This is the worksheet he sat and looked at when he sat in that counselor's office. Those are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. and there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths. James Crumbley failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have driven around with him. He could have not done any DoorDash round until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his DoorDashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack. Never thought then to say, hey, can I talk to you out in the hall? Or, hey, where's that gun? Didn't ask his son where that gun was. Didn't check the journal, despite acknowledging he had one. Didn't lock and secure ammunition. Didn't lock or secure the gun. Didn't take his son home. Didn't take him to get this care that a counselor's telling you he needs. Didn't say, we bought him a gun 4 days ago as an early Christmas present. And didn't tell the school much relevant information at all. And Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumbley was concerned about it. James was always home. Is he home yet? Is he home yet? Is he home yet? Leave me alone, I have to work. He's fine, is what he says. The incident about giving him melatonin and him being worked up. Didn't tell him that he'd asked him for help and asked to go to the doctor. Told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with. That there were multiple guns in the home, that he was begging for a 9mm. James Crumbley never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. And that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for 1 day? We know it wasn't there on Saturday. We have the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with his gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home. Expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock. And all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet. Until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it, until after the shooting. We know that at 10:37 he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation, he saw cop cars. We know that 12:51, the shooting starts, and we start to see students and parents, we heard, arrive at the Myre. They're being told by dispatch that's where their unification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Myre parking lot. It's unclear exactly why. He calls his wife for 57 seconds. The call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone and so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter, and it was James Crumbley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency?
Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to the high school. I have a missing gun at my house. I need an officer to come to my house right away, please.
Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation.
I understand that. There's a million cops there. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I was down, and I saw a whole bunch of cops going somewhere, and I made sure that I wanted to get to the high school, see someone going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to find out. Okay, and I think my son took the gun. I don't know if it's him. I don't know what's going on. I'm really freaking out. My son's name is Ethan Crumbley. Crumbley.
E-W-Y. All right, sir, I'm going to put you on hold for just 1 second, okay? I have to talk to Cookman and see if I can do anything for you, okay? We'll put you on hold.
Thank you.
Okay, then.
You just heard this. I have a missing gun. My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school, and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he says, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on this morning, what's he talking about? He's talking about the meeting and the words on the paper. It says, help me, blood everywhere, with a picture of the gun he bought him. So I raced home and I found the gun missing. We went into detail about what James Crumbley and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else. And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he receives it from his wife, he's concerned, my God, WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when the shooting started or when it ended. I think he owed something to the parents and the kids in that school to at least try, once he did figure out that the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid, doesn't get into trouble, yet he was looking up bullets, and yet they were called to the school and the drawing. He doesn't say that, or what the drawing was really about. It's a downplaying situation, and then he says the gun was hidden. And again, never once, I don't know how he got it. Never once says that. James Crumbley had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing, and we know that because we know what his response was when he received the drawing. He kept those concerns private that morning. But he didn't just fail to inform the school. He failed to act. James Crumbley failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son. He failed Hana. He failed Madisyn. He failed Tate. And he failed Justin. He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents too. And I ask that you find him guilty. Thank you.
Thank you, Prosecutor. Ms. Lehman?
Yes, Your Honor. There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that day had on them. Multiple people told you what that day was like. They told you what they felt. They told you what they saw. And they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hana St, Juliana, Madisyn Baldwin, Tate Myre, and Justin Shilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others, and that James acted in a grossly negligent manner or breached a duty that he owed to other people, despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021, and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. When it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have one or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't. Because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, If James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that. But you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing-assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and her client didn't testify, and so it's just not evidence what he was doing, and it's just not. And his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw texts between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw them. Saw James and his son. And saw no concerns. Not worried. Didn't hear anything. Didn't see anything. Wasn't made aware of anything. No concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning. Told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son. Right in front of Sean Hopkins' desk. Sat next to him. Went over the piece of the math assignment with him. The drawings. What was on there. That he was caring. That he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all. Just that one may exist. And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself more than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun. She didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they believed that James and his wife were going to get their son help. That they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't.
More courtroom coverage in the trial of James Crumbley from the Hidden Killers podcast from True Crime Today is coming up. Press subscribe now so you don't miss a minute.